Good afternoon, everybody. Welcome and thank you for joining us today. Welcome to the BHBA's 2020-21 Entertainment Litigation Year in Review panel, the cases that rocked the entertainment world in 2021. I just want to quickly say the slide that was just shown, I just want to point out that it's really important. I'm the VP of Scholarships for the Beverly Hills Bar Foundation, and we really do need to keep those scholarships going. It's for law students that are interested in public interest law. And so I do encourage everybody to go to the Beverly Hills Bar Foundation's website, which was listed on the slide, and can be found on the BHBA's website. There's a link there too. And please donate whatever you can to help with the scholarships. A couple housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members only community. Please take a moment to complete the survey that is included with your certificate. And with that, I'd like to introduce myself. I'm Pierre Pine. I'm a partner at the entertainment litigation firm of McPherson LLP. And I want to, first of all, throw out a couple thank yous to my co-chairs, John Valdivia and Katrina Crosby, who helped put together the fantastic materials that we have. It was, for those of you who haven't seen it yet, every year we put together case summaries of all the important cases. We'll try to get to as many of those today as we can, but we are definitely not going to get to all of them. It's a 50-some page case summary, so there's a lot there. And I want to also thank Loeb and Loeb, who put together the base of these summaries. We add to them and put more things in, but we certainly want to thank them for their continued support and allowing us to use their case summaries. A couple quick introductions before we get started. I'm very excited about this panel. Three fantastic attorneys who I've dealt with in various either cases or KJ as a law school professor, and Marc on other panels, and really excited to get going with them. Peter is a partner in Davis Wright Tremaine's Los Angeles office and has 4 decades of experience in copyright and entertainment litigation. He was lead counsel in the Stairway to Heaven litigation, winning a jury verdict of non-infringement, followed by the en banc decision of affirmance. He successfully defended Green Day and Seltzer versus Green Day and has obtained summary judgments from multiple artists, record companies, and music publishers, including, for example, The Weeknd and others in Smith versus Weeknd. KJ Greene, Kevin Greene, is a graduate of the Yale Law School and a U.S. Marine veteran. Professor Kevin J. Greene is the John J. Schumacher Chair Professor at Southwestern Law School in Los Angeles, California, where he teaches copyright law and entertainment law. Professor Greene practiced law in New York at the premier firm of Kravitz, Swaine, and Moore, representing companies such as Time Warner, HBO, and at a top New York entertainment law boutique firm, where his clients included film production companies, film director Spike Lee, and music artists including Harry Connick Jr., Bobby Brown, and the seminal rap group Public Enemy. And last but certainly not least, Marc Toberoff. Marc is the founding partner of Tobroff and Associates and a leading attorney in the area of copyright and entertainment litigation. He's been called the legal man of steel and a superhero of rights holders by Variety and a brilliant crusader for the little guy by the New York Times. Marc is a relentless, dedicated advocate of creators' rights. He has successfully represented numerous high-profile clients in a wide variety of intellectual property and entertainment transactional matters, ranging from the children of James Brown and Ray Charles, respectively, to the heirs of Jerry Siegel, Superman's creator, and of Jack Kirby, the artistic genius behind most of the Marvel movie franchises. Recently, he successfully represented the creator of Friday the 13th, both in district court and the Second Circuit, and we're going to talk about that case. Marc's currently representing the co-creators of Spider-Man, Iron Man, Thor, Black Widow, Hawkeye, Blade, etc., and 5 copyright lawsuits with Marvel. Let's jump right in with some general copyright cases. Peter, tell us about the Stars Entertainment LLC versus MGM.
Absolutely. It's a district court decision by Dolly G in the Central District. As a backstory, though, to put it in context, It relates to Petrela versus MGM, which is a 2014 Supreme Court decision that ruled that latches is not a defense in a copyright infringement case. Because the court was, the basic principle was that since there's a statute of limitations, that should govern. If Congress wanted to allow latches, it would have also provided for latches. And so the court, in the course of its decision, talked about how the statute of limitations works, the 3-year statute of limitations in 17 USC 507B. And it had in the body of the opinion some very absolute language, like, quote, under the Act's 3-year provision, an infringement is actionable within 3 years and only 3 years of its occurrence. And the infringer is insulated from liability for earlier infringements of the same work. A successful plaintiff can gain retrospective relief only 3 years back. So it had all this absolute language in the body, and which seemed to say it's 3 years and you're out. But in a footnote, the court said that, or recognized that many circuits have a delayed discovery rule that benefits, that basically extends the 3 years, or it doesn't start the 3 years from running until you knew or should have known of the infringement. And the court stated that it had not passed on the discovery rule. So you had this clear language in the body saying it's 3 years and you're out, and you had a footnote saying we haven't passed on the discovery rule. And so for the last, since 2014, people have sort of been saying, what does this mean? Does the statute of limitations, disbar claims after 3 years or not? And of course, defendants have said it's an absolute bar. The Second Circuit, in a case called Sohm, S-O-H-M versus Scholastic, sort of cut the baby in half and said, well, delayed discovery survives Petrela, but since it says you can't get damages for more than 3 years before, even if you sue for an infringement, say 5 years early because of delayed discovery, you can do that, but you can't get damages for the for the infringement beyond 3 years. So it's sort of the legal definition of a Pyrrhic victory. I mean, you basically can sue, but damages are out. Injunctive relief is probably moot because of the, so much time has passed. And so that's the basic concept, background or context of Stars versus MGM. In Stars Entertainment had licenses going back to 2013 with MGM, under which MGM had granted exclusive rights in some hundreds of movies. And at one point in 2019, a Stars employee was watching Amazon.com stream movies and saw that they were streaming that classic movie, Bill and Ted's Excellent Adventures. and for some reason, he actually, this employee, actually, recalled that was one of the MGM movies that Stars had exclusive rights in. So Stars went to MGM. They actually looked into it and found 20 other ones. They went to MGM. MGM apologized and said, well, yeah, we see there's maybe 200 of these movies. And then Stars really looked carefully, and it was more like almost 400 movies. So they filed an action in the Central District for copyright infringement and breach of contract. And the MGM moved to dismiss on the grounds that under Petrela, you can't go back more than 3 years. And many of these infringements, about 140 of them, if memory serves, were barred by the 3-year statute. So what the district court did was, first, it went through the history. It recognized that the Ninth Circuit has long recognized delayed discovery to extend the time to file suit, going back to Polar Bear versus Timex and an earlier case, Rowley, which implied it, but Polar Bear made it clear. And said, the district court said that, well, the Supreme Court did have this absolute language, but it also said, we're not dealing with that issue. It expressly passes on the issue. That the language in the opinion is actually past tense, that we haven't passed on it before, and one can make the argument that they did in the body of the opinion, but that didn't sway the judge. And so she got it down to the concept that the Ninth Circuit has long allowed delayed discovery, that the Supreme Court's decision doesn't overrule any of those decisions. And in considering Sohm, the Second Circuit decision, she recognized, I think correctly, that it doesn't really do you any good to be able to sue for an infringement more than 3 years ago if you can't get any remedies for it, or at least any damages for it. So she ultimately denied MGM's motion to dismiss on the grounds that the Ninth Circuit's delayed discovery rule survives intact after Petrela. That's the principal issue. There was also an issue of whether, and this I just want to mention because it's kind of funny, I think, whether the delayed discovery rule helped MGM, or Stars rather. MGM argued that they were openly and notoriously infringing. And so that Stars should have known it. And in some great language, the judge said, basically, look, you're supposed, a licensor is supposed to be diligent, but, unless there's, smoke, you don't have to look for fire. And they had no reason to suspect that, that MGM was basically selling the rights twice.
Right.
So the end result is that case will continue, and ultimately maybe we'll have a Ninth Circuit decision, and we'll see, if it aligns with the Second Circuit or if it goes back to the Supreme Court.
Did you guys want to comment on that one, or should we get to the Desire versus Mana Textiles? Peter, why don't you tell us about Desire versus Mana Textiles?
Okay, that one also has a backstory to put it in context. It relates to statutory damages, and Desire versus Mana is a Ninth Circuit opinion. And in the district court, it's one of the many fabric cases that my friend, Mr. Doniger, has filed. The issue on statutory, and he won summary judgment on liability, or on some issues, then it went to jury trial. And there was a company that had made the infringing textile, and then it provided it to, I think it was 4 or 5 different retail outlets. And so what the plaintiff argued was that the issue was how you can, how many different statutory damage awards can you award? And the language in section 501c1 is an award of statutory damages for all infringements involved in the action with respect to any one work, for which any one infringer is liable individually, or for which any 2 or more infringers are liable jointly and severally. And this language led the Ninth Circuit in Columbia versus Krypton, maybe 20 years ago, to rule that you look at how many different people are individually liable, or defendants are individually liable, and how many are jointly and severally liable. In Columbia, Mr. Feltner, who owned a bunch of television broadcast stations, had licensed the rights to a bunch of some 400, episodes of television series from Columbia, breached the license, and Columbia terminated the right to continue to broadcast, and Mr. Feltner didn't care and continued to broadcast them. And so the way statutory damages were whacked up in that case was that Mr. Feltner was jointly and severally liable with station A, jointly and severally liable with station B, et cetera, et cetera. So you had multiple jointly and severally liable groups of people, and you ended up with multiple statutory damage awards as to some 400 different television episodes. And the award was, I think, $38 million. So it was a lot of money. And the Ninth Circuit said, yeah, that's all fine. The Ninth Circuit revisited that in Friedman, where there was a similar kind of argument, and they realized in that situation, because there were many more jointly and severally liable groups, it could be a dramatically large award for a relatively small infringement. And it also recognized that in this kind of the way commerce works nowadays, you could have awards in the trillions of dollars if that kind of approach is done. But they threw their hands up and said, but that's not for us to decide. That's what the act says. And so, and we don't have to decide it here because they didn't sue the jointly and severally liable people. They only sued the individually liable defendants. So they were able to avoid the issue. Desire, again, involved a situation with one defendant who prepared the infringing textile, and then the 4 or 5 different defendants who received it and sold it at retail stores. And the district court awarded, after jury trial, awarded separate statutory damage awards that totaled, I think it was $480,000 against these, 5 or 6 different people, defendants. And the Ninth Circuit in Desire said, well, yeah, but you're not reading the statute right. That rather than a separate statutory damage award for any group, it's really, you get one award no matter how many jointly and liable people are. Basically changing it from any to whether,
Right.
one award, whether there's an individual or groups or whatever. And so they just said, no, you get, one single award. And the dissent.
Yeah, Judge Wardlaw had, pointed out some possible long-term effects. If you want to talk
Right.
about that.
Yeah, that's what I was just about to get to. Judge Wardlaw, of course, predictably said, yeah, but you're overlooking Columbia, you're overlooking Friedman, and you're overlooking the actual language of the statute. But she also pointed out something that, and we have to see if this actually gets borne out, is that a plaintiff can avoid that result in at least 2 ways. One way is you file separate actions against each group of jointly and severally liable people. So whereas in Desire, they had a single lawsuit in front of a single judge and a single jury trial with 5 different groups of jointly and severally liable people, that same plaintiff would be encouraged by the Ninth Circuit's decision to file 5 separate lawsuits with 5 separate trials, each with a separate group of jointly and severally liable people. And Judge Wardlaw pointed out you could also just punt on the individually liable defendant, just sue every retail outlet that has any of the products.
Right.
And either way, all you're doing is you end up with the same result as Columbia. You get separate statutory damage awards, but you have just multiplied the amount of litigation in the district, in the circuit. So that is Desire versus Mana.
Aside from the fact that the plaintiff will get bucked because it was limited to just one statutory damage award.
Right.
Correct?
I'm sorry, I don't follow.
It is, you know what bupkas means?
Yes, I know what bupkis means. I grew up on the west side.
I'm saying aside from the fact that it essentially reduces the value of getting statutory damages to an oil slick. It loses its value if you're limited to one statutory damage.
Yeah, I should mention the first 20 years of my practice, I sued movie studios and others on behalf of plaintiffs. So while now I do mostly defense work, I'm not, insensitive to the idea that, there's a reason for statutory damages, and plaintiffs should be compensated in some form when they can't establish actual damages. So, I'm not taking a position on that. It just seems like the Ninth Circuit dodged the issue, but didn't do it successfully because all it does, because there's ways around it.
Right. Creates more issues.
Right.
Why don't we move on to fair use? KJ, tell us about Grant versus Trump.
First of all, I just want to say thanks so much, Pierre and Beverly Hills Bar, for inviting me again. I think this is my 3rd or 4th time speaking with you guys. It's very rewarding to see Pierre Pine, such a successful lawyer. He was once my student way back when, I think, in my entertainment law class. And also gratified to be on this panel.
I want to say.
Also glad to be on this panel with both Peter and Marc. Of course, Peter, I cover your Woods v. Universal Studio case, and I see you've got the 12 monkeys by there. Yeah. Anybody can get an injunction against Universal. Wow, that's enormously impressive. And Marc, I also talk about a lot of your work in my classes as well, particularly the Dukes of Hazzard case and the I think it was a $15 million verdict or settlement in that case. So very exciting to be here with all of you guys. So Grant v. Trump. Was that?
More.
It was more than 15. Okay.
No,
I see you're smiling, Marc. I see you're smiling.
I can't disclose it, but it was an asset.
Awesome.
It was leaked.
So we got Grant v. Trump here, of course, in August 2020. Mr. Trump was in the middle of his campaign at that point, and he decided to tweet a video which has been uploaded to Twitter by someone else. And we wanted to show the video, but we're not showing it because the Zoom interface with videos is so horrible, but I can play you a little bit of the song. That's an issue.
It's an old school 80s.
Boy.
All coming back to me.
Now in the street there is violence, and then lots of work to be done. No place to hang out, I'm washing, and then I can't blame all of this sun. Oh no, we're gonna rock down to Electric Avenue.
That's the Electric Avenue song written by Eddie Grant and owned by him and his publishing companies, who were both plaintiffs in the suit. And of course, Eddie Grant wrote that song in response to riots in the UK. They were race riots in the UK throughout the 1980s. And so some people view it as a protest song against that. And he's singing about the people in Brixton, which is basically the ghetto, for lack of a better word there. So I think the context of the song is important. You could imagine that someone like that probably wouldn't enjoy his song being used in a campaign ad that was promoting the candidacy of Donald Trump, who has been sued or has been threatened to be sued by many music artists, not named Kid Rock or the guy who does God Bless the USA, but it seems like everybody else pretty much doesn't enjoy them using their music. The video had a train basically, and the video was basically trying to show that Trump is powerful, he's the fast train, and Biden, who was in the ad, is the slow one, right? According to the facts of the case. A slow-moving hand car operated by an animated likeness of President Biden, and it bears the word President Biden President. Your hair smells terrific. So that was it. Of course, in the lawsuit, the Trump campaign countered with a fair use defense, and so the court went through the four-factor test, which we're all quite familiar with, or if we're not. I just want to say, students, by the way, even though I know a lot of these cases, I did brief all of them, okay? So that's, I told my students this morning, right? You got to do it. We teach you to brief cases for a reason, right? So you'll be able to actually do this and function. Of course, the first factor is the nature of the defendant's work and whether that work is transformative. Now, of course, in Sony, back 25 or so years ago, the court stressed commercial use as an important component of that, but it seems like that's been put on the back burner, right? They don't really talk about commercial versus non-commercial. It seems like all the money in fair use, quite honestly, is on factor one, and that is the defendant's work sufficiently transformative to that it adds something new, special, or unique that would take it out of copyright infringement. Of course, parody is a very strong basis for that, but this was not really considered a parody by the court. And so for that reason, the Trump campaign has a real problem here. It was no commentary. All they do is they use the song. And by the way, they use a lot of the song. Even though the ad isn't very long, the court said it's 78% in the ad. And so that's a major problem. They're not doing anything to comment on the song, to criticize the song, to say anything about Eddie Grant, the author. All they're doing is using the music. And so that's a big problem for them. It says that it does not use Electric Avenue as a vehicle to deliver a satirical message, and it makes no effort to poke fun at the song or at Eddie Grant. So I think we can end right there, because the rest of the factors, once we reach that conclusion, we know who's going to win this case. Once I say there's no transformative use, that's true in most of the cases. Also, in factor two, of course, we look at the nature of the plaintiff's work. That would be Eddie Grant's work, whether it's primarily creative or it's primarily factual. And of course, it is a creative work, a very creative work, actually, the song Electric Avenue. So we'll give that to Eddie Grant. On the third factor, we look at how much is taken. And of course, there's two prongs to that. We have to look at how much quantitatively is taken and how much qualitative is taken. And I think it was Harper, right? The Harper case, the Supreme Court case, they say, right, also, did you take the heart of the plaintiff's work? Well, bing, bing, bing. The court thought all of the above, that they took too much, and they took the most important part of the song, which is the hook of the song. And so we're going to give that factor to Eddie Grant. They play almost the whole song. And finally, the fourth factor, which I think previously, and I'd like to hear what Marc and Peter think about this. It seems previously that factor also had a lot of legs, but it seems like that's receded a lot too. It's still important, but it seems like factor one is it transformative or not out of the Pretty Woman case is going to be the #1 thing. And the Trump campaign tried to say on the fourth factor, which is what is the economic impact on the work? They were trying to say, well, actually, there's no economic impact on the Eddie Grant song because this is a political campaign. And the court said, no, not so fast. It's not about whether the work will be impeded because somebody else is making money. Here, the Trump campaign is getting publicity and they can potentially getting campaign donations, and we can use that. And they also said that it will harm Eddie Grant's rights in a derivative market for use in campaigns. And so it's a skunk for the Trump campaign on all four factors, right? You can't do this. You can't take Eddie Grant's song, use the whole song, put it in a campaign ad, and then try to say, well, it's political, so therefore it's protected. That's not the law.
KJ, I think on you mentioned the commercial use element, which doesn't seem to be as strong anymore.
Yes.
I think it was the Curry case where there was a discussion in that case, and it's not in the materials because it's not a new case. But,
right. That's the painting of the Rastafarian guy.
Right.
And
right.
They put the blue face on him.
Yeah. But I remember there was a discussion in that case about the commercial use and how if you dig deep enough, really, you can almost find a commercial use in almost everything now. So it's really difficult to use that as a disqualifying factor. So I think they tend to kind of brush past it now a lot more.
Yeah, very interesting, the transformation, because back in the Sony, the Betamax case, I mean, that was the whole ball of wax, right? It was commercial versus non-commercial.
Right.
And then, of course, we got the Acuff Rose, the Pretty Woman case, and they really shifted that completely. So I don't know, as lawyers, how much time we should even spend on the commercial versus non-commercial distinction, But it didn't work here. This is, in essence, commercial use because they're not making money traditionally, but they're using his song to basically boost up the campaign. That also works.
Yeah,
so
and they also, obviously, the court stressed on how, I mean, it was, what was it, like a 50-some second commercial ad or something, and they used 41 seconds of it was the song. So
right, it was 80% basically.
Yeah,
Eddie Grant in the ad.
Yeah, a lot of use, which you could definitely differentiate from the use. Why don't we? I think that's a good.
I bet you Marc or Peter would have settled this case, right? Why go ahead and get a ruling? I mean, you're not going to win.
I think that segues well into Brown versus Netflix because there we were talking about a much smaller. Well, why don't you give us the?
Well, first of all, my apologies because it's funny. It's a good thing that I did stay up last night to brief these cases because I was thinking of the other Brown case, which was Bobby Brown and the documentary involving Whitney Houston. And I know that case, and I actually didn't know this case. I didn't know about this case. So I was glad that I actually took a look and I actually briefed it. So we can talk about that briefly. Of course, this is May 2021 in the Second Circuit, and it's upholding the district court's opinion. And the plaintiff is created a work that's called fish sticks and something else. What is fish sticks and
tater tots?
And tater tots. Sorry about that. They and the defendants, that was in 2011. They created the song. They own the rights. You love them, huh? Me too. I know. I'm getting hungry now. I'm gonna have more of my beer here, I think, right before this is over. Not a beer. Defendants released a documentary, and it was on burlesque, right? So I don't know what that has to do with fish sticks, but part of it was released, or all of it was released on Netflix, Amazon, and Apple. So it was obviously very successful for these plaintiffs. My question I put in parentheses, what would the clearance on this look like? And I was wondering underneath this, is this a clearance failure on the part of Netflix, Apple, or Amazon, right? Should someone have caught this? I'm always interested in the clearest aspects of stuff. I know, Peter, you're interested in that as well. Should this have been cleared better? It was 8 seconds of fish stick song in a 3-minute burlesque routine. So they didn't use a lot. It used the chorus and it used the dance routine. That sounds like that to me might be the heart of the work when we get to the fair use part of it. The dancer was wearing a reverse mermaid costume, whatever that is. And it had fish head and fish legs. Then she goes behind the sign, she changes out, she removes the fish head, and she turns into a fish stick, right? So she goes from a fish into a fish stick. And the rest of the dance routine didn't have the plaintiff's work. It had just other stuff that was in it, according to the facts. that she sued, the plaintiff sued Netflix, Amazon, and Apple. And of course, this would be infringement because it would be an unauthorized distribution of the song. It would also be a public performance, and it could that could be copyright infringement. The defendants filed a 12B6 motion to dismiss this case for failure to state a claim, and the district court granted the motion and dismissed the case. The Second Circuit agreed with that, so the plaintiff prevails here. They found that 3 out of the 4 factors were present under the fair use analysis we just did: the purpose and character of the use, the amount that was taken, and the effect on the market. They didn't really comment on the nature of the copyrighted work. Again, that seems to whether it's creative or factual, which is the second factor, that seems to be out the window in the fair use analysis. The Second Circuit, in a roaring affirmance of that dismissal, said, "Hey, documentaries. I think that was the most important thing. It was documentaries are in the heart of the zone of fair use, and they found that this use was transformative. They took the fish stick and tater tot song in the burlesque routine and transformed it into something different." And they actually cited Carew v. Prince, the case that Peter was talking about before, in order to support that. And they say that even if it was commercial, the first factor would still make this fair use. They didn't care about commercial, non-commercial in this case at all, once again. They only took 8 seconds, so that's good for the plaintiff. Not too much was taken. And they did take the heart, but it was not, it was transformative. They go back to transformative, even in that factor of how much was taken. Anything else we want to say about this? On the market issue, they say there's no way that a children's song intended for children is going to be usurped by a burlesque routine, which actually I presume is going to be showing a lot of skin, right? I didn't see the routine, so that, you know, the kids aren't going to be going to the burlesque show, okay? So the market's not really harmed here. A ringing a victory for the plaintiff and for documentary makers too, for it. So, but clearance failure here. Should somebody have caught this, or at least flagged it? Maybe they did, right? We don't know what went on behind the scenes.
I think the case turned on the fact that the mermaid suit was inside out and no one knew what it meant.
The reverse, right?
Inside out or upside down?
Upside both.
Well, I guess it's possible too that the lawyers at Amazon, Apple, and Netflix, they might have looked at it and they might have said, great, they gave it the green light. That could have happened as well. That's not in the case, so I don't know.
Yeah, I haven't heard any details on the background of it, but yeah. I don't know, the 8 seconds kind of caught my ear, you know, just, it was such a small amount, it might have slipped under somebody's nose.
Yeah, and these defendants are very well financed.
Right.
I don't know if Marc or Peter are advising a small, you know, documentary film with a low budget, if they pass on it or not and say, great, you can do it, right? It's probably a different analysis then.
Well, I don't do clearance work. My firm does a lot of it. Mm-hmm. And, you know, I don't know that they were involved in this one, but my observation would be if this was cleared, they got it right.
They did get it right.
I mean, so,
they got it right.
So it's not a clearance mistake.
Right.
But for the small production company, you have to tell them. The only way you'll know is after a federal court tells us whether it's fair or not, right?
Yeah, that's what
that'd be very expensive.
Yeah.
Yeah.
Peter, quickly, why don't we go through the O'Neill Rochatowski case, which is it's pretty interesting, I thought.
Yeah, it's a Southern District of New York decision. It involves one of these many instances where a paparazzi takes a photograph of a celebrity and the celebrity then posts it on Instagram. In this case, the model Rochatowski, whose name I'm sorry I just butchered, was leaving a flower shop in Manhattan, and some paparazzi, Mr. O'Neill, took a photograph of her, and apparently when she saw him coming, she put the bouquet of flowers over her head, over her face, covering her face. And she posted it on Instagram stories, which means it lasts for only 24 hours and then it's gone. And
we know that well, Peter, from another case.
Yes, exactly. and she captioned it "Mood Forever." And so, of course, she pulled a motion for copyright infringement. I just want to mention quickly before getting into fair use that the defendant challenged whether the photograph was original. And the judge said, well, look, it's barely original. It's a low standard, but the photographer contributed the lighting, angle, and focus. Now, the lighting was the ambient lighting outside the store.
Right.
You know, that the photographer had nothing to do with it. He didn't put up Klieg lights. He didn't put up reflectors or anything. It was just what was there. The angle really depended on how the model moved. If she moved straight towards him, it was a straight on shot. If she moved to his left, it was, you know, from that angle. And focus just seems to me to be an odd thing to suggest that, well, he decided to put it in focus rather than unfocused. And
Right.
he was probably using a camera that had autofocus. So it just seemed like, you know, that was really pretty generous to get past originality. On fair use, the defendant's argument was that she was making a statement by showing that, yes, I covered my face with a bouquet, and that is my mood forever when a paparazzi tries to take a photograph of me as I'm just doing, you know, my shopping or something.
And I think she added a caption to her photo that was kind of like my mood, or it was some kind of.
It's just the two words, mood forever. And
Okay,
her explanation of that was that she was conveying that, see what happened, this paparazzi took my photograph, I hid my face, and that is my response, my mood forever to people who just jump in front of me and try and take photographs. And the judge said, well, you know, there's a genuine issue here. That seems reasonable to him. You know, that explanation seems reasonable, and he's basically got to accept it since there's declaration supporting it. In terms of the first factor, the purpose and character of the use, the question was whether adding those two words was transformative. And he said, could be, there's a genuine dispute there. I don't know if Perez Hilton is still doing it, but if everyone who knows him, that's what he did. He would take photographs and just take a pen, like a marker, and write a word across it and say, oh, it's fair use. So this is basically the same kind of an idea. As to factor two, nature of the work, the judge said it's a straight on photograph of someone walking out of the store. So it's basically factual in nature. It's not like, you know, the Mona Lisa or something like that, where he painted something. It's basically, you click the photograph and he depicted her exactly as she was. And so it's basically not the most creative works. It's more factual in nature. The amount used, it was the entire photograph that the paparazzi had taken, but it only lasted for 24 hours on Instagram. So that cut against a finding of non-fair use. And factor four, and I thought this was interesting because of what Professor Greene was saying, that factor four is sometimes ignored. Apparently no one put in any evidence or any allegations as to, you know, the commercial effect.
And there you have it.
You know, they punted on factor four. So the judge said, look, no one's saying anything about factor four. So I can't rule as a matter of law that that cuts one way or the other. And so it goes to trial unless it settles.
But yeah, I thought it was interesting because you see a lot of these, you know, it's a typical thing with celebrities who get, you know, have the paparazzi following them and get these candid photos, and some of them do put them up on their page. So at least they know, you know, do something with it. Make it at least a question of transformative. Don't just post it. Don't just repost it.
Add something. Add something.
It seems to me that was a good summary, by the way. But it seems to me that we need clarification on what the scope of copyright protection in photography is, because what you just said, it seems like basically just a normal snap is going to get very, very little copyright protection, and as you were saying, might not even meet the standard of originality. So, and I know photographers are probably the most aggressive litigants, aren't they, in the copyright space? Aren't you more likely to get sued over a photo than anything else in this space? So some clarification that would be helpful, right?
In this
I only have one case in the First Circuit.
Oh, sorry.
Yeah, go ahead. The Harney case. It's the Harney v. Sony Pictures case.
In the Central District, I think it's fabrics and photographs that, you know,
right.
filed every day. You know, if you go back to Burrow Giles and the Ninth Circuit's Etsy vodka case, you know, they have this long list of you know, angle, f-stop, background, props, posing the subject, you know, choosing the subject, all that kind of stuff. And you know, it's pretty compelling. You know, you can look at a photograph that really involves a lot of creative decisions. It's easy. But when you've got some guy, you know, maybe not alone, maybe there's 5 paparazzi who are all, you know, shouldering, trying to get a photograph of a celebrity, and they take it from the angle they got, you know, depending on where the guy comes from. And they take it in the ambient light, and they got autofocus. You know, it's kind of hard to really, you know, identify what's going on in a creative nature. You know, I mean, it almost sounds like sweat of a brow.
I
You
think
know?
of I think of the Obama.
Is that called the Ansel?
AP
Is that called
photo.
the Ansel Adams defense? The Ansel Adams defense? They're not Ansel Adams. Or Richard
Yeah,
Avedon?
exactly.
Oh, no, not at all. I think even an amateur can take a remarkable photograph, and we've seen
Right.
cases like that.
Right,
It's not an issue of, and that's a good point, Mark, because I don't see it as an issue of the skill of the photographer, more an issue of whether that skill is used in making that photograph. So,
Peter, do you think she had an argument that she was a co-author?
well, you know, that's an interesting thing, because I think generally that's the case, but she didn't, you know, participate with the intent of making a unified single work.
Sure.
You know, I think if you're talking about, you know, taking a photograph of Professor Greene where, you know, he's choosing things, the props and stuff, there's a case, Broad versus Collins, an unpublished decision in the Ninth Circuit that I had years ago, where the guy who did the book that had the photograph actually sat there and said, no, use this prop, you know, do this, look through the camera and said, okay, now you can take the photograph. And the court said, yeah, those are co-authors. You know,
Right.
he was instrumental in making creative decisions that are reflected in the photograph. So it's not an issue of this, to me, it's not an issue of the skill of the photographer. It's rather whether that skill was applied to the photograph.
That's a good standard. I'm thinking of the Obama AP
I think that's a
case, right?
very, very difficult standard to apply.
Well, and I think it's generally sidestepped. And I think this case is an example where the court said, well, you know, there's creativity and focus, lighting, and, you know, whatever the third one was. I think that's debatable, but, you know, no court is going to say, and we know that from Etsy in the vodka case, where it was just a straight on shot of a vodka bottle. The court said, no, that's, you know, potentially, you know, original. Ultimately, the plaintiff lost on a separate motion, but.
Well, let's keep it going. I want to get Marc going with the Friday the 13th case. Marc, tell us about Horror Inc. versus Miller. I mean, this is a long kind of, you know, give us the history, and I know you've been involved in it for a long time. So
it's interesting. The last time I spoke at a Beverly Hills Bar Association panel, it was just at the beginning of the Friday the 13th case.
I was on the panel with you. You, me, and
I was
who's starting the third movie.
I was probably speaking overly confidently about our chances of success, but turns out those comments were prescient. So I usually represent artists, creators, writers, authors, who, to use a legal term, have been royally screwed. And I use provisions of the Copyright Act, such as the termination provisions, to level the playing field and get for them what I think they are truly owed, both in terms of recognition and in terms of money. The case Friday the 13th was no different. Victor Miller was a young aspiring writer working out of his house. His best friend was a young aspiring producer working out of his garage. And when Bad News Bears came out, the producer probably in Miller's kitchen said, hey, you know, let's rip off Bad News Bears. And they did Bad News Bears only in soccer. Wasn't successful like Friday the 13th. Then when Halloween came out, it was a huge hit. The same producer in Victor's Miller, they both said this took place in his kitchen, said, hey, let's rip off Halloween. and you know, not using rip off in the copyright infringement sense, but let's emulate Halloween. So Victor Miller went down to the local theater, watched Halloween, and started feverishly writing the treatment. You know, I forget the name. I think it was called like Bad Day at Crystal Lake or something like that. And proceeded to, and then started writing drafts of the screenplay, and proceeded to, the producer, we believe, used that literary material that had been, we believe, it was written on spec to get financing from the movie, and then it was papered over with a short form WGA employment contract. Friday the 13th, of course, became an incredible success. And the producer went off and produced, I guess, 12 Friday the 13th movies, made a fortune. And his best friend was left in the dust, and I think received something like, I forget, under 20,000 for his literary material. I forget the total amount. In any event, I was brought in. We sent out notices of termination to capture the copyright under Section 203A of the Copyright Act, and which allows you to, for those who don't know, it allows you, it's a remarkable provision that allows an author to recover their copyright without cause. Has nothing to do with contract principles. By filing notices of termination of the original transfer of copyright. And so we did that. And the other side claimed what they invariably argue, the sole exception to termination, which is that the work is a work made for hire. Now I'll get to that. I'll get to that in a second. They filed suit. They included a lot of other state law claims, I believe for purposes of intimidating the author, but that's just my humble opinion. And we went at it. I viewed the case in a very straightforward fashion. Work for hire law was reformed in the 1976 Copyright Act in the definitional section, Section 101. And it essentially is two-part. I'll just pull it up. It's a two-part definition. Work made for hire is one, a work prepared by an employee within the scope of his or her employment, and two, a specially commissioned work for certain types of work which are listed, which include a motion picture of an independent contractor. But in the second case of an independent contractor, the independent contractor must have an agreement in writing, and that agreement must state, must use those magic words and state this is work for hire. So, and part of the reason for that definition, I believe, in subsection 2 of the work for hire definition is to clear up prior abuses under the old Copyright Act, where in the 60s, virtually everything was held to be work for hire under a very loose and vague instance and expense test. So here we are in the case, and I looked at the case very simply. I said, it's not work for hire. He's an independent contractor. He's working out of his house. There are no indices of employment. You didn't withhold taxes from his measly writing fees. You didn't give him paid vacation. And intuitively, we know he's an independent contractor. You guys were just friends working out of your houses, trying to get arrested in the movie business. You know, but they argued the only thing they could argue, because we had them dead to rights as far as not being work for hire if he's an independent contractor. So they said, no, he's an employee. He's his best friend's employee. And the definition employee for purposes of work for hire means traditional hierarchical employment. And they had their back against the wall of the Reed case, in which the Supreme Court said employment for purposes of the work for hire definition refers to traditional hierarchical employment. And you analyze that by going through the usual agency factors that one would expect under the common law to define employment. Because when a word in a statute like employment is undefined, you define it under the common law. And the factors that you look at are the factors you would think you look at. Did they withhold taxes? Was there paid vacation? Were there set hours of work? The degree of control over the creative process. And then there are some less important factors.
They made some interesting, and interesting, I take that. I mean that in a broad way, but arguments for additions to try to make to the Reed factors, I think, like you said, they were kind of back against the wall, trying to tie it to labor law.
And in the Reed case, I'm going to get to that. And in the Reed case, they did say that the factors were non-exclusive. So they, with nowhere else to turn, they claimed that by definition, he's a traditional employee because he was a member of the Writers Guild. The producer had used a shell company, which was a signatory of the Writers Guild. And that therefore, they argued that since only employees can be members of a guild, and you can only have a guild under the Taft-Hartley Act, if it's a guild of employees, therefore, he's an employee as a matter of law. That was their argument. Our argument was that dog don't hunt for a number of reasons. First, copyright is not subservient to labor law. Each law has their own their objectives to various different statutes, whether it's the Taft-Hartley Act or the Copyright Act or Civil Rights Acts. There are many statutes where the one has to define whether someone's an employee to fall under that statute or an employer to fall under that statute. And you look, but even in that instance, and we listed all of these statutes, they define employment the same way by looking to the common law agencies factors, just like in Reed. And in fact, they refer to Reed. And that, and that secondly, so you have to apply the factors in Reed and the factors that were emphasized by the Second Circuit. Number two, even on its own terms, their labor law argument was wrong, because the Taft-Hartley Act says that the bargaining unit of a union has to be composed of employees, but you have independent contractors who can be members of the unions. And in fact, the Writers Guild, the majority are independent contractors. The only thing close to traditional employment in the movie business is when writers are part of a staff in the writer's room of an ongoing television series. But generally writers that are writing, and they write scripts on spec they're both employed to write scripts, and they write scripts on spec all the time. So all of a sudden, all these spec scripts by independent contractors who are members of the writers is turned into work for hire by virtue of the fact they're merely a member of the Writers Guild. That doesn't work. And in fact, we also pointed out in the history of the Writers Guild, it goes back to the Screenwriters Guild, when labor law was different, and labor law at that time applied to independent contractors and employees equally. So, and we traced the whole history of the Writers Guild Agreement, and then we did our analysis under the Reed case, which involved a lot of, noodly factual discovery and presentations of facts. And we prevailed in the district court, and the Second Circuit affirmed. One of the interesting aspects of the case is that we actually left the case with more than we expected to achieve going in. And this is quite interesting. So the termination, the Copyright Act has no extraterritorial application. It only applies in the United States.
Right.
So therefore, when you serve termination notices and recapture the copyright, you're recapturing the US copyright. The original grantee would continue to own whatever foreign rights they were granted under the original grant. So the opposing counsel, in this case, Greenberg-Glusker, argued that the terminations are ineffective because they apply to terminations of transfers, and all we have here was an employment agreement, and that therefore there's nothing to terminate. Therefore, there's no place for the termination provisions because it's just an employee agreement. And we argued that's not the way it works. When an architect is hired by a real estate developer to design an office building, and the architect designs that office building and receives money for the office building, for the design, if later upon challenge, that agreement falls short of a work for hire agreement, you think they have to tear down the building? No. The court finds an implied transfer. And I showed by piecing various definitional provisions in the Copyright Act together, that in fact the termination provisions can terminate implied transfers as well as express written transfers. But now that you brought it up, I said, this means as follows. You're right, there was no express transfer. And this was a contract entered into in 1979 or 1980. And therefore, you could have implied exclusive transfers under the 1909 Copyright Act, but under the 76 Copyright Act, an exclusive transfer of copyright has to be expressed. Otherwise, it's deemed to be an implied transfer only of non-exclusive rights. So I said, opposing counsel is absolutely right. There was no transfer. Thank you. That means all you ever had were non-exclusive worldwide rights to the original Friday the 13th literary material. And now that we've gotten back exclusive US copyright, we are left with exclusive US rights and non-exclusive foreign rights to Friday the 13th, which is a tremendous asset, because when you just have US rights, the holder of the foreign rights can effectively block, since it's in general, making movies or TV series is a worldwide business, and investors are expected to recoup from worldwide exploitation, although that will change. Generally, that gives the original grantee blocking rights, or their successor blocking rights.
Right.
And here, that is not the case.
That's great.
So they
I
were
wanted to ask you something.
Yes.
Marc. So first of all, thanks for the summary. I did put in my article on copyright terminations for the materials, and one of the things I talk about in the article in the music space is, I think maybe perhaps different than the motion picture space, is that a lot of these music artists, and I'm thinking of hip hop artists in the late 80s and 90s now who were in the termination windows, they don't even know. I've seen this, a mainline hip hop artist from those days was about to miss their window because they didn't even realize this is happening, but we could talk about that separately. But in the context of the motion picture, how valuable are these literary rights, pretty much the rights to the script? How actually valuable are they going to be, and how are they going to be utilized, given the fact that you already have a movie made on that same subject matter? I was just curious about that.
What's the question?
He gets back. He doesn't get back the rights to the Friday the 13th movie. He gets back the rights to the original script, right, or early versions of it.
But
so I'm wondering, what's the potential economic value in those?
I think it's very valuable, of course.
Well, I was going to say, and Marc answered what I was going to ask, but I mean that the Section 203 and 304 both say that termination has no effect outside the U.S. and no effect on non-copyright rights. And so, following up on what Professor Greene said, in the normal situation where you terminate a grant of motion picture rights, all you've got is the exclusive rights in the U.S. alone, which doesn't really do anything because no one's going to invest the money in a motion picture if they don't have worldwide rights. Plus, in your situation, Marc, arguably what the studio could do is continue to use the title for new sequels, but just stay away from the protected material in your literary work. And so kudos to you to jump on the argument that there was no transfer at all, because that's what gave you worldwide rights. And that's what potentially makes it valuable. But my experience, and I don't really do this, but I've seen it happen, is that recaptured motion picture rights in the US alone really are very tough to exploit. I have one example that I won't name that goes back 30 years, where the family that recaptured the motion picture rights to several different movies haven't been able to get any studio interested because they don't have foreign rights. Plain and simple,
All right. Well, I would disagree with that. First of all, when you're dealing with the branded, what I call branded entertainment, and Friday the 13th is definitely branded entertainment. There's tremendous interest in that, so that if the studio, when you get back these rights, when the studio wants to, it works in reverse. They say, oh, you have blocking rights. And I said, no, you have blocking rights. We have all US rights. And then we enter into a negotiation. So there's value in the fact that when they went to make another picture, they're not going to take the position, oh, we're going to use the title, we're going to carve around. They're not going to go move ahead with a new project without making a deal. So there's value there. Secondly, the underlying assumption without foreign rights, you're stuck, you can't do anything. Whereas that was generally true, that's changing. With the advent of streaming, you see, there used to be just 5 studios, now there are 30 studios. And the streamers are overtaking the studios. They could buy a studio and turn it into a museum, essentially, Netflix. And so they, the only disadvantage the streamers have is they don't have libraries to draw from. So if you have rights to a valuable franchise property, you're dealing with the Netflixes and the Amazons and the Apples. Netflix has established Netflix Spain, Netflix France, Netflix Australia, and they are making content at fairly significant budgets just for that territory. So there must be a price point when you're dealing, for an example, with a valuable horror title, in which they view it as very valuable, even if it's US alone.
Yeah, and hey guys, I want to kind of start wrapping up because we're a little bit over now, but
okay.
I want to get to some questions. But I understand what Peter's saying, but I think it may be more on a case-to-case basis, because I think in a movie, in a franchise as long as Friday the 13th, I don't think it's likely the studio is going to want to create a non-connected to the original film. The origin story is the origin story, and if you're not going to stick to that, then I don't think the fans are going to be as quick to come back. I think there's a reason why we haven't seen a Friday the 13th movie in I think it's over a decade now, and certainly since before the lawsuit. And I think people are waiting to get these, hoping that these rights will get resolved. The case will get resolved one way or another, and a deal will get worked out where somebody will combine the rights and get a new film out. I mean, you're seeing, you just saw the new Halloween movie do hand over fist money, and Scream just came out with a new one. So I'm sure Friday the 13th people want to see, a new real Friday the 13th movie, and
Right, and that seems to be the real value, because you have the script rights to the original. You can do all sorts of derivatives and spin-offs as long as they don't infringe on what the studios have done, right? Because there's been so many Friday the 13th. But since he has the original source material, right, he's free to use that to make derivative works out of it. And it seems like that's where the real value is to me. And he would have all rights in those works, not just U.S. rights.
Let's get to some questions. I want to thank you guys. That was great.
And the case is resolved.
Yes. So hopefully now we'll, I'm sure all the fans who've been waiting with bated breath to get a new Friday the 13th film are wondering, hopefully a new film will get made in the next couple of years. But let's.
I'm not playing Jason.
What's that? What was that, Mark? I didn't hear that.
I said I'm not playing Jason.
All right, well, let's, so we've got some questions. Let me see. This is goes back to I think this is about the O'Neill Rochatowski case. Is there any problem on the value of a paparazzi photo because he or she doesn't have the right of publicity, so the potential uses are narrower?
Well, the right of publicity is state by state, but generally, if you take a photograph of someone in public, it's not a right of publicity issue as long as you're not using it as an advertisement. At least that's my understanding, and maybe the other panelists can chime in. But if all you're doing is you're selling it, to be posted on a website about gossip or a website about celebrities, then that doesn't really create a right of publicity issue, in my understanding, in California or any other state. If you took it and you put it on the box of, Quaker Oats or something like that, you'd have a problem. But, these generally don't involve right of publicity claims. Right. In fact, there's been attempts, and they haven't worked, for the celebrity to sue, or at least threaten to sue, the photographer, saying you're violating my right of publicity. So it's actually an interesting issue, but as a practical matter, the way these photographs are used isn't implicated.
I think this is probably for Marc, because it sounds like we're talking about terminations. Can a sound recording or a song apart from an audio visual work be for hire? But anybody can jump in on it.
The answer is yes, it can be. If you've got an employee, that's the litigation that's going on, is, if it's not mentioned in one of the categories, 9, I think they are, that Marc mentioned in the definition of work for hire. If it's not an employee and you have a written work for hire agreement, but it isn't one of the 9, whatever they are, different elements, record companies have often taken the position that compilations are included. And so if a recording is on it's compiled into a mastered recording and compiled into a CD or an album. But right. That's an issue that's being hotly litigated. I think there's even I think Evan Cohen has a class action, I think, going on Right. I think you're right about that.
Marc, I think the recording companies have kind of tried to, when it comes to these music and master recordings, both sides have kind of shied away, usually from litigation, and have settled these cases, particularly when they deal with a major recording artist, where you're dealing with master recordings of tremendous value. It's almost like they don't want a ruling on this hot topic issue of whether a master recording, as opposed to the underlying composition, is a work for hire and therefore terminable. There's tension between the provision I mentioned, applicable to independent contractors, where it says that you need an agreement that says this is work for hire. And although, that was fundamental in the Friday the 13th case, that they had no such agreement, there's tension there because you also have, and this was under the, termination provisions of the 76 Copyright Act, but it involved work for hire under the 1909 Copyright Act. And you had a settlement agreement that it dealt with Captain America. It was Marvel v. Simon in the Second Circuit, and you had a settlement agreement where he had argued that he was entitled to the renewal copyright. It wasn't a termination case. And then he signed a settlement agreement. And in that settlement agreement, he received some money. And he said, I hereby acknowledge and declare that everything I did for Captain America was work for hire. The termination provisions contain a very important provision that says, notwithstanding any agreement to the contrary,
Right.
an author or the author's statutory heirs have termination rights. So the Second Circuit held that to the extent the declaration in the settlement agreement that this is work for hire, you can't, to the extent you're ruling that that's dispositive, that becomes an effective waiver of the termination right. And it's an agreement to the contrary. You need to apply the facts of the law. You need discovery, and then you need to apply the facts of the law to decide whether or not it in fact was work for hire. You can't go, so there's tension between that decision, which I believe is correct in the Marvel v. Simon case, and that section 2 of the work for hire definition in the 76 Copyright Act.
We went up to the Ninth Circuit with George Clinton, and the district court had basically allowed a law firm to, in essence, expropriate his sound recordings in order to pay a debt that was owed to that law firm. And the district court didn't do any read analysis. All they did was looked at Warner Brothers' contract. The contract says that it's a work made for hire. They also register the sound recordings as works made for hire, which in my mind is a false copyright registration because they're not works made for hire. These artists don't get salaries, they don't get vacation time, they don't get an office, they don't get any of those things. So the whole thing right now is a charade. And you're right, I think courts and parties alike are afraid to really tackle this in the sound recording context. The other kind of fly in the ointment is that so many of these artists got into loan out corporations. And if the work has already been transferred, section 201E, I think it says, is that it's too late. If you own the rights and you transfer them, then you can no longer terminate those grants. So in short, it's a big old mess, right, for it. But I'd love to see some authority on this. Congress, as you guys know, punted on this in the early 2000s. First, they put in that sound recordings could be work for hire. Then they took that out. Yeah. And when they took it out, they said, the fact that we put it in and we took it out, you can't use to say either way, whether we think they are works made for hire or whether they're not works made for hire. And so, yeah, right now, the big artists are just settling, right? And they're settling with the labels rather than the fight this, the Princes and the likes of the world. But yeah, this is one of the messiest, unresolved issues in music copyright law.
But I think there will be a big case in the near future.
Mark, someone asked, why wasn't the WGA agreement that you mentioned a sufficient written agreement covering a commissioned work for hire?
The WGA agreement doesn't mention work for hire.
That's what I figured the language.
It doesn't utter the word work for hire. They stay very far away from copyright issues in the WGA agreement.
That's pretty much it. Thank you guys very much. This has been great. I really enjoyed it.
A lot of fun.
It was fun.
Yeah, it's great.
My only regret is we didn't get to shake it off, but maybe next time, right?
Yeah, there was a lot of cases I would have loved to get to, and I'm sorry we didn't get to more of them, but you guys did great, and this is fantastic, and I appreciate you guys being on. Thank you very much, and thanks
Pierre.
Thank you for the invitation.
Thanks, Pierre.